What are the rules for police canine unit searches? Imagine walking down the street when suddenly a police dog sniffs around your car. You might wonder, is this allowed? Well, the rules for police canine searches are based on the Fourth Amendment, which protects against unreasonable searches and seizures. The first thing to know is that a dog sniff by itself is usually not considered a search. The Supreme Court has ruled that a trained police dog sniff to detect illegal drugs only reveals whether contraband is present, not private information. So, if a dog sniffs outside your vehicle during a traffic stop, the police don't need a warrant or probable cause. However, the police cannot just call in a canine unit whenever they want. They need a reasonable suspicion that you are involved in criminal activity before extending your stop to wait for a dog. This means they must have specific reasons to believe you might be carrying drugs or other illegal items. If they prolong your detention without this suspicion, it could violate your Fourth Amendment rights. Once the dog alerts to the presence of drugs, that alert can give police probable cause to search your vehicle or property without a warrant. But for the alert to be valid, the dog must be properly trained and certified, and its reliability can be challenged in court. The training and certification records of the police dog are very important. Courts often requiring proof that the dog is tested regularly and trained specifically to detect drugs. If there are gaps or irregularities in the training records, it might be possible to challenge the dog's alert and the legality of the search. In some cases, police can get a search warrant based on a dog's alert. To do this, they need to submit an affidavit showing probable cause that evidence is at the location. Without this, they cannot legally search without your permission or a warrant. There are also limits on how police can use canine units. They cannot use a dog to bypass constitutional protections by stopping you without reasonable suspicion. The dog must be lawfully present, usually outside a vehicle during a legal traffic stop. If the dog alerts, the search must be limited to areas where the dog could have detected the scent. And importantly, the officer's subjective intent to use a canine without proper suspicion does not justify extending your detention or conducting a search. From a legal point of view, these rules are designed to protect your rights. If you believe police violated these rules during a canine search, you or your attorney can challenge the evidence in court. The key is whether the police had the right reasons to call the dog, whether the dog was properly trained, and whether the search was conducted within constitutional limits.